Joining us now is Mark Meuser, counsel with the Dhillon Law Group Incorporated.
My name is Mark Meuser. I'm an attorney with the Dhillon Law Group. We do a lot of political litigation, and our firm has represented in the past President Trump, the RNC, the California Republican Party.
Gavin Newsom had to violate the California Constitution, and he redrew the lines in a way that's going to subject the state to litigation for years.
Hey, Mark Meuser here with the Dhillon Law Group, and today we're going to be talking about the Supreme Court case of Louisiana versus Calais. In this particular case, the Supreme Court is looking at the question of whether the time has come to end affirmative action in picking of politicians.
The U.S. Supreme Court heard 2.5 hours of arguments in the Louisiana congressional redistricting case, Louisiana versus Calais. At issue, whether creating a second majority-minority district violated the U.S. Constitution.
You see, what is going on in the state of Louisiana after the last census, they had to draw the lines. And Louisiana had 6 congressional districts, and they ended up drawing one district that's called the Voting Rights District. It is a district that is designed under the Voting Rights Act to ensure that minorities have representation in Congress. And so they drew one of their 6 districts as a minority-majority district, a district that ensured that Black Americans in Louisiana would be able to vote for one congressman of their color. No sooner had Louisiana published their maps than they were sued by some liberal activist groups who said, no, you should have drawn 2 minority-majority districts. And a federal judge said, yes, Louisiana should have drawn 2 VRA districts in Louisiana. So under protest, the legislature of Louisiana sat down and they redrew the maps so that there were 2 minority-majority districts. And the second district that they drew went all over the state looking for African-American neighborhoods to draw into this gerrymandered district. And no sooner had they published the maps of this new redistricting, where there are 2 minority-majority districts, then the non-majorities sued the state of Louisiana, and they said, wait a second, these districts were drawn with race in mind, and this violates the 14th Amendment, the Equal Protection Clause of the United States Constitution. And they won. And so this case was appealed to the United States Supreme Court, and the state of Louisiana threw their hands up in the air, and they said, wait a second here, court. We are darned if we do, darned if we don't. We are between a rock and a hard spot. When we drew one congressional district, we lost because we did not draw enough minority-majority districts. But then when we drew 2 minority-majority districts, we were sued because race predominated in our drawing of the lines. What is a state to do? And see, in order to understand the problem that the state of Louisiana is, we need to wind back in time. You see, back in the 1960s, Congress passed the Voting Rights Act. They did so under Section 5 of the 14th Amendment, which gave Congress the power to pass laws to enforce the Equal Protection Clause. And at that time, the Voting Rights Act, Section 2 of the Voting Rights Act, generally followed the language of the Equal Protection Clause and said that in drawing the congressional districts, you were supposed to, ensure equal protection. But as time went on, it became clear that there were certain states that were allowing race to deprive minority groups of equal representation in Congress. And Congress decided that they needed to amend the Voting Rights Act. And in it, they kind of created a quota system. Affirmative action for politicians, you could say. And they basically said, if you can draw the lines to ensure that minorities are able to elect a congressman, then they are to do so. And the Supreme Court took the Voting Rights Act and they came up with a 3-part test that state map makers must use in order to determine when they are to draw congressional districts, basically these minority majority districts, affirmative action districts for politicians. Well, the problem is that as time has gone on, it has kind of created a scenario where map makers start drawing their maps from the voting rights districts and then go out from there. So the first thing that they do is, do we have to draw any voting rights districts? And when they are done with that, then they say, let's divide up the rest of the state. That is one of the things that kind of has happened here in the state of California. As part of this Louisiana versus Calais case, the attorneys at Dhillon Law Group, we submitted an amici brief to the United States Supreme Court in which we talked about the work done by the commission, the Independent Redistricting Commission here in California. And we studied the transcripts of the Independent Redistricting Commission, and we found that well over 60% of their time was spent drawing these voter rights districts. They started with these voter rights districts and then shaped the rest of the state as a result thereby. A couple prime examples of this would be up in the Central Valley. They decided that they needed 3 of the 4 congressional districts to be voting rights districts, which meant after they framed the 3 voting rights districts, everything else in the Central Valley ended up being the other district, which created this monstrous district that went from Fresno clear down around Bakersfield, around the bottom of Bakersfield, and back up the western side of Kern County. It is an ugly district that was created because map makers started with the factor of race. Race was a predominant factor in these minority majority districts, and then everything else got squeezed into a congressional district. This happened time and time again throughout the state of California because they predetermined that they needed to draw 14 minority majority districts. And so a part of our amici brief to the United States Supreme Court was to highlight the fact that when race is a predominant factor in drawing of congressional districts, it not only affects the district, the voting rights district, but it affects all the surrounding districts. All of a sudden, you start dividing cities and counties because you have to try to squeeze all the minorities into a particular voting rights district. So during the oral arguments of the Louisiana versus Calais case, a very important fact was brought before the Supreme Court, and that is 3/4 of all the black congressmen are elected from districts that are not VRA districts. Thus, only 1/4 of the minority congressmen elected come from districts in which politicians or judges have tipped the scale in favor of minority groups. What does this mean? One of the interpretations of this is that 2025 America is not the same as 1960 America. Back in the 1960s, to be a minority, it was almost impossible to get elected to Congress because white Democrats would not elect a black Democrat. That environment is no more. What we are seeing is that the need to draw affirmative action districts to pick our politicians based upon the color of their skin, that need may no longer be necessary. And so what the Supreme Court is looking at in the case of Calais versus Louisiana is, since we no longer live in a district where the color of one's skin is a deciding factor of whether or not you are going to be elected, and that voters in the United States seem willing to vote for a person based upon their principles and what they stand for, has the time come to remove race as a predominant factor in how we draw our congressional districts? Here in California, if we remove the factor of race, that would mean that the map makers are no longer be looking at what the color of your skin is. Instead, they're going to be working to keep your cities and counties as compact and in the same district, if at all possible. It will change the factors so that race no longer is a predominant factor. And when race is a predominant factor, what it means is that there's no longer a competitive congressional district, and it means that special interests are controlling who gets elected in these safe seats. The time of racial gerrymandering may be at an end in the United States of America. The time of affirmative action for picking our politicians may come to an end. Those who have studied what the Supreme Court's oral arguments is and the questions being asked by the judges, it seems very clear that the two swing votes, which is Justice Kavanaugh and Justice Roberts, that they are very open to the concept of reevaluating whether the three factors of the Gingell's test are even necessary anymore. This is Mark Meuser from the Dhillon Law Group, and this is Anatomy of a Lawsuit.